This is video 2 for weeks 6 to 7 civil practice and its personal jurisdiction. And in the first sentence, I note that this posting is to go along with pages 18 and 20 of the handout, and also contains some additional material which we'll be talking about. Our assumption here is this. A lawsuit has been commenced, and we'll talk a little bit more about filing, but summons and complaint, for example, have been properly filed. You know, we're cool with statute of limitations, and if there was a notice of claim period, we're okay with that. And the next thing that one has to consider is will the court have personal jurisdiction over the defendant? When we picked out the court, we had to worry about the court's subject matter jurisdiction, the court's power to adjudicate the dispute before it. Personal jurisdiction is the court's power over the parties to a lawsuit. It refers to the court's power to make a decision regarding the party who's being sued. We don't have to worry about personal jurisdiction over the plaintiff, because the plaintiff, we could say, consents to personal jurisdiction by bringing the lawsuit, but the defendant not so. There's going to be two areas that we want to examine. The first area is, has the defendant been properly served with the summons? And again, in most instances, the complaint will go along with the summons. More of that later. But so we have to be concerned about proper service of the summons and complaint, and or the notice of petition and petition. And then the second area, which we'll get to in a bit in this screenshot video, is if it's New York State Supreme Court, is there going to be a territorial or geographical concern? But let's just focus on how the summons and complaint has to be served. And I have set forth different methods of service on page 18 of the textual outline. And what I point out, we don't need to memorize this stuff. We should know, however, and when I say we don't need to memorize it, let me tell you what happens in the real world. And I'll just use where I hang out as a lawyer as an example. We're going to bring a lawsuit, and we need to get the defendant served. I'm going to get a hold of, or have one of my folks get a hold of, a business that serves people. They're in the business of, we could say, of serving process. And then I'm going to leave it up to them to properly serve the defendant. And obviously, I'm only going to use that business if I have confidence in their ability to properly serve the summons and complaint. So that's really how we're going to do it. So neither myself nor any staff is going to be hung up about how do we do it. I need to know in case we run into difficulties, or better said, if the process server runs into difficulties. But I think it's an undue burden to have you memorize those different methods. But what we want to know is that the person serving the summons or notice of petition is, as I say in the handout, is descriptively known as the process server. In New York State, and this is where we're working right now, an individual 18 years of age or over and not a party to the action can serve the summons or notice of petition. The lawyer and the lawyer's staff are not considered a party to the action. I know that in a pinch once I served a summons and complaint, and I was able to legally, because I can assure you I was over 18, and also I wasn't a party to the action. In New York City, the process servers are required to be licensed by the New York State Department of Consumer Affairs. I think that's really the New York City Department of Consumer Affairs, but let's not worry about that. More power to you if you end up working in one of the 5 boroughs in New York City. I did for a while, and it's very exciting. But we're focusing really on the rest of the state, so we just need to have that person 18 years of age or over and not a party. What I would also say is that again, we're going to be relying in every law office I'm aware of, from the large firms to the very modest-sized place where I hang out, it has somebody who's in business to do that. Excuse me. A vital point I notice on service is in divorce cases, we do need to serve the defendant personally, or if that cannot be accomplished by court order. Most cases, however, as I noted in the handout, there's alternative methods of service. Even when there's alternative methods of service, like me, I think most lawyers prefer, or like most lawyers, I prefer personal delivery on the defendant, because it's a practical matter. It eliminates the defendant's ability to say that he or she did not receive the summons. What always rankled me over the years is service proper, but not personally on the defendant. Defendant doesn't appear in the case. We take what's known as a default judgment. Now, of course, we start to enforce the default judgment, but let's say we freeze the defendant's bank account. The defendant now has religion, goes to a lawyer, and the lawyer is going to claim, by virtue of what the defendant is going to be saying, the defendant didn't know he, she, they, it were sued, and we can go around and around in a circle that we can avoid if we just serve the defendant personally. It has to be that way in a divorce case. What's not covered in the handout, but what I want to add, not covered in the textual outline, but what's I want to cover here is how personal jurisdiction sometimes requires an analysis of the defendant's links to the court in which the defendant has been sued. And again, we're just focusing on New York State Supreme Court. And what we're going to do is break this into 2 categories. Residents of New York State and non-residents. The concept sometimes is known as domiciliary. That means where is a person's permanent place of residence. If we wanted to get very technical, we would say, where does a person intend to be living on a permanent basis, with the understanding that the person may then change that. Most of us regular folks, where we live is where we're a domiciliary. Some folks live in different states. They may have their home in New York City. They then may have a place in Palm Beach, Florida, and they may have a place where they go skiing occasionally in Aspen, et cetera, et cetera, et cetera. Where we have that different states of address, one of those places the law insists is going to be the permanent residence. It can be worked out. Where is a person licensed? Where is a person registered to vote, et cetera. But let's assume that it's clear that we either have a defendant who is a resident of New York, or second category, a non-resident of New York. And what we end up is that if the person is a resident of New York, there's never any problem, because the New York State Supreme Court will always have personal jurisdiction over that person, no matter where the person is served with a summons and complaint. So you live in the city of Buffalo, and for some reason you're visiting someone in Minnesota, and you're sued in a case in New York State Supreme Court, and your service actually takes place in St. Paul, Minnesota. New York State Supreme Court is going to have personal jurisdiction over you. It doesn't matter where you were served, so long as you were a resident of New York State. Where we have a non-resident, then we have 2 general rules. and that would be number one. If the non-resident is personally served while in the state of New York State Supreme Court has personal jurisdiction. So let's assume that the non-resident is visiting Buffalo. You know, one of those many people who like to go to Buffalo for vacation. And while vacationing in the Queen City, the person served with a summons and complaint in a lawsuit in New York State Supreme Court. The court will have personal jurisdiction because the person was served in the state. If the person who's a non-resident is served outside the state, let's assume that person who was vacationing lives in Charleston, West Virginia. Well, then it's going to depend upon whether the plaintiff's claim is related to the defendant's conduct in the state of New York. And it will be, for example, if it's based on a motor vehicle accident that happened in New York State or a contract that was either negotiated or was supposed to be performed in New York State. But we need that link. Sometimes this concern about whether the court has personal jurisdiction over a non-resident who's served outside the state is referred to as long-arm jurisdiction, long, L-O-N-G, arm jurisdiction. And you can imagine that the court's, New York State court's arm is reaching out to New Jersey to exercise personal jurisdiction over the person who lives in New Jersey, served in New Jersey, and that's, again, cool so long as the claim is related to the defendant's conduct in the state of New York. So that'll end this video.